43 page. But the same person was sold to the borrower in the year 2001. Later, the fourth respondent mortgaged that property to my bank.
The person, the mortgage title deeds you have from Shri Rupa Kini. She is the one who's done that. So where is the title deed in her favor?
Page number 140. Memorandum of deposit of
143.
I put for. Bit of the department was also secretary. Is 4,400 square feet. And the assessment property is totally.
So where is the deed? This is only a memorandum. Where is the deed?
That is the title deed, memorandum of title, deposit of title.
Memorandum of deposit of title deeds is a memorandum under which a title deed is deposited with you. Where is the title deed?
Title deed is given. Absolutely.
Copy of the title deed. The finding of the learned single judge is that there is no title deed.
Sale deed is given. That was produced.
You see the reasons.
Annexure C and C, D and E. Well, Annexure H. Annexure sale deed dated 22/9/2001.
No, the sale deed of the petition of the respondent is a sale deed. He holds a sale deed of 22/9/2001.
That property is different. The reallotment on the reconveyance of the VDA given by the VDA is different property, and only he was in physical possession of mortgage property. Can he be the owner of that property? That deed he was produced that deed also. That is in 97, page number 97. The measurement is also different, and the boundaries also different. East by belt of land, site number 2, north by road and south by belt of land. Our sale deed property is different. The same person executed sale deed in 22/9/2001.
Rupa Kini has deposited a document of Khata number 72. How does she get this property?
The same first respondent executed sale deed in favor of Rupa Kini, fourth respondent.
So show us the title, chain of title deeds.
Annexure H. 107. This is in Canada. Sale dated 22/9/2001.
107.
Page number 107. Annexure H. So type of copy next to page number 120.
No, this is a different title deed.
That property is different. This property, Khata number is same. 72, 16 D9 division 74 Kodi Hilly Village, Worsu Taluk, Bangalore South Taluk, Worsu. That measurement is 4,400 square feet. That was mortgaged to us.
You show us the title deeds which have been in your possession and chain of title deeds.
Please.
Finding is that the title deed which you have doesn't have any vendor. And the person who's deposited the title deeds can't trace her title.
Each side.
Learned counsel for the appellant requests 1 week's time to produce legible copies of all relevant title deeds, including those under which the appellant respondent 1 claims title. This
3rd September. Number 28.
It's all right.
Number 28. Srinivas scale.
My lord, the appellant, this case, my lord, is a bona fide auction purchaser, wherein, my lord, in the writ petition, appellant is ranked as respondent number 3, wherein, my lord, this impugned order is produced before your lordships at page number 24, my lord. The prayer also is very much visible at the very next page. This impugned order is passed behind my back, my lord. No notice is served upon me. Despite the fact I am the bona fide auction purchaser, a possession certificate is also issued in my favor. That is at, my lord, the sale certificate at page number 89. Page number 89, the sale certificate is issued and the possession on the very same day is delivered to me. The case of the petitioner before the court is that, my lord, seeking restoration of possession. That being the case, my lord, the learned single judge comes to the conclusion directly to direct the banker to restore the possession despite the fact I am in the possession. No notice is served upon me, my lord. My natural justice is directly violated.
No notice is issued.
No notice is served.
All right, issue notice. You have a delay of 459 days.
Yes, my lord, because I got to know about the impugned order only on 19/6/2026. I have clearly evidenced that in page number 145 in my IM. Wherein, my lord, in fact, a fraud was played on me by the tenants who are continuing their possession, taking undue advantage of the order passed by the learned single judge. Only recently, when the banker informed me, I got to know about the impugned order being passed.
3rd November.
Great.
Number 29.
I appear for the appellant in the matter. Lords, the appellant is a club. It's registered as a society. Lords, there was an inquiry.
How would a writ petition be maintainable? How would
Pardon?
a writ petition be maintainable?
My lords, I'm sorry, I did not follow.
How is a writ petition maintainable?
My lords, I filed it against the order of the registrar. My lords, the order your lordships will find at annexure A, my lords, at page 62 it starts. Page 67, my lords, against this I have filed a writ petition as the club.
Page 67.
Please, my lords, it's a translation of the impugned order and the writ petition.
Yes, all right.
My lords, in this order, there was a direction to place the enquiry report once again before the general body, my lords. Now, this, my lords, is directly contrary to the order in the trial court, my lords. I'm just passing that.
Because now the management committee has changed.
No, my lords, the management committee has not changed. There is the enquiry committee was dissolved. One of the persons who was named in the enquiry has filed an OS. In that OS, there's an injunction order that was also brought to the notice of the learned single judge. My lords, in the daily orders, he holds that in this.
No, I think the learned single judge proceeds on the basis that you had no locus to represent the club.
My lords, learned single judge proceeds on the basis that, kindly see, my lords, with due respect, my lords, the factual narration itself is incorrect. Kindly see page 33.
Page?
Page 33.
Yes.
My lords, the learned single judge proceeds on the basis that the managing committee itself reviewed the report, and therefore the managing committee itself has dissolved the enquiry committee, and therefore it says that because there's a vested interest, it could not be done. That's not the fact at all, my lords. Kindly see page 33, para 2. An internal inquiry has been carried out as regards certain allegations made in respect of excess spending by the managing committee. My lords, it's an inquiry committee. It's not a managing committee. There's a specific body of 5 persons. Managing committee made out an observation and sent it back to the inquiry committee, pursuant to which the review report has been submitted. My lords, that was the general body itself which said it has to be reviewed. This aspect was challenged before the registrar. My lords, the challenge before the registrar was to a special general meeting in which they rejected this report. The inquiry committee members themselves approached the registrar, saying that the report by them has been rejected by the special general body and that meeting itself is invalid. Then the order says, the registrar, by way of the impugned order, observed that the report against the managing committee could not have been placed before the managing committee, but would have to be placed before the general body, while the impugned order dated so and so. It was indeed before the general body.
Issue notice.
My lords, now my difficulty, my lords, is I have to have the annual general meeting in August. Now, if I were to place this, then
Give
my
you a
lords,
short notice.
very well.
I filed an application for impleading.
You are,
I am one of the members, my lords, have challenged the inquiry report before the civil court. Civil court has granted an injunction
If the
order.
plaintiff in the suit, my lords,
I'm the
kindly
plaintiff in the
order
suit.
in the injunction.
let him join, you join up we'll consider your application. List.
My lords, I have to give 21 days notice for the AGM, my lords.
And that's true. We have to hear them. This is a dismissal. Even if give you even staying this order doesn't help you.
My lords, your lordships
Your
will permit
petition.
us to go ahead with the annual general body meeting. In the event your lordships were to find that this report has to be once again placed, then your lordships may direct a special general body to be convened at that time,
You can,
subject to the outcome of the OS. My lords, the annual general
there
body
is
can.
no restrained order.
My lords, there is.
Oh, there is a
kindly-
direction.
Kindly see the order I just handed over, my lords. The order in OS 1307 of 2025.
You should notice the appellant is at liberty to proceed with the general body meeting. To issue notice for the general body meeting. This will be subject to further orders that may be passed. List on, put it in about 10 days time. You proceed with the notice, we'll hear it before your 21 days expire.
My lords, I have to issue 21 days before the meeting, my lords.
Therefore, we said you can issue the notice. Your meeting will be scheduled.
Please, my lords.
We'll list this matter and you serve the notice to them.
Please, my
And
lords.
your notice that we are permitting you to issue is subject to the further orders that may be passed.
Please, my lords. My lords, then in which event there will not be an agenda item regarding this report?
That's what we're
There has
saying.
to be an agenda.
You can,
There has to be an agenda for approval.
so you can proceed with the issuance of a notice without placing the report before the general body meeting in its agenda, without having an agenda of placing the report. Then this will be subject to further orders that may be passed.
Very well. I'm ready.
My impleading application is before my lords. There is one objection raised by the office, my lords, insofar as filing of application.
We'll consider your application on the next date.
Great.
Other parties be present.
I'm ready.
But you serve them.
I will.
10th August.
My lords, the state can
I'll take
take notice.
It's for number 1 and 2.
1 and 2.
Then council will respond 1 and 2 exceptions.
So 10th of August. So number 30. Kavita and 14%.
Permitted, I would like to file compliance report, my lord, insofar as accused number 3 is concerned.
My lord, in this matter, the management has sent the recommendation for promotion in May 2026. It is before the director, my lord. It will be done in a week's time.
Permitted, my lord.
In fact, your lordships have given the date to 18/9 for compliance. They have moved the matter early.
Permitted, before I take my lords through the compliance affidavit, my lord, if I may persuade my lords to kindly take the order that is passed by the learned single judge.
No, it's
Lord
a
would find
specific,
the order at page number 7, my lord, of the petition. Kindly come to the operative portion, which is at page number 15, my lord. Paragraph number 7.
yes.
In view of the above, this writ petition is allowed. The respondent number 2 and 3, that is accused number 3, my lords, are directed to promote the petitioner to the post of lecturer in mathematics in BL Composite Pre-University College, Jalahalli. Respondent number 1 is also directed to approve the promotion of the petitioner as lecturer in mathematics and consequently grant all the constitutional benefits to the petitioner. Now, my lord, the petition is filed contending, my lord, she is entitled for promotion with effect from 2023. My lord, that is not found in the operative portions. Now, if I may persuade my lord to kindly take the compliance affidavit, my lord may kindly see the resolution, annexure R2, page number, my lords, 8.
Yes.
My lords, we have passed a resolution on 13/4/2026 itself, my lords, stating that the complainant herein is entitled for promotion and it should be recommended. Annexure R3, my lords, on 17/4/2026. My lord, we forward this resolution and we also intimate the complainant herein that she has been promoted. She reports to duty, my lords, annexure R5, page number 11, pursuant to the promotion. Page number 11, annexure R5 on 27/4/2026. Now, if my lords would kindly see annexure R6, page number 12. It's in Kannada, my lord. It's in vernacular language. Page number 13 is the translated copy, my lords. Lord, we also write to the accused number 2, that's the deputy director, my lords, stating that, my lords, requesting for the approval of the promotion. Now, that is pending before accused number 1 and 2. That approval has to be granted.
The approval is pending, my lord. It will be done in a week's time.
Respondent number 3 is filed in compliance affidavit, enclosing therewith a resolution dated 13/4/2026 for promoting the complaint. Pursuant, the said resolution was also communicated to the complainant on 17/4/2026. She reported for duty on 27/4/2026 at 12:40 p.m. It is stated that in view of the above, it is stated that that respondent number 3 is duly complied with the order dated 27/5/2026, the disobedience of which is alleged.
My
25 passed in WP 8268 of 2024. Full stop. The learned counsel appearing for respondent number 1 and 2 states that the approval is being processed and would be processed within a period of 1 week from date. List of.
my lord,
Just put it after a week.
my lord,
Yes.
my lord. Actually, my lord, the judgment is based on the Karnataka Education Act grant in aid rules, my lord. In the page number 5, according to Rule 18, promotion to the cadre of lecturer and to the post of principal in a composite private pre-university college. In a composite private aided pre-university college, 50% of the total post of the lecturer shall be filled by promotion from the cadre of secondary school assistant if on the date of arising vacancy, a secondary school assistant is eligible for promotion. The judgment is passed under Rule 18 of Karnataka Education Act grant in aid rules, my lord. Also in the judgment, my lord, it is clearly granted in the page number 9.9. The respondent 1 is also directed to approve the promotion of the petitioner as a lecturer in mathematics and consequently grant all consequential benefits to the petitioner, my lord. My lord, on 28th. My lord, on 28/4/2025, my case was live telecasted, my lord, on the day. both management advocate as well as the government advocate agreed for the promotion, my lord.
No, that's right. They're only giving.
No, my lord, and a management advocate agreed that they delayed promotion of 10 months. They agreed, and they agreed that because of their delay only, my promotion was not held up by them. From the past 3 years, I am in the same state, my lord. So I am applying all my personal leaves to come to court only, and I am suffering from the past 3 years, and they agreed that because of their delay only, my promotion has held up. And in the promotion list, my lord, in the page number, yes, my lord, in the page number 43, my lord, with the reference to above, Srimati Kavita M, Assistant Mistress, BLB High School, staff number S02992 has been promoted as a lecturer in BL Composite PU College, Jalahalli, Bangalore, with the effect from 13/4/2026, my lord. The judgment is passed on 18/2/2026, my lord. They are making a delay of 2 months, and in that they are given that with the effect from 13/4/2026. That means they are influencing the both the department to promote me from this date, my lord. I received a phone call from the principal of BLPU College on 24th to receive this promotion letter, my lord. On 27th morning, I have received the promotion copy.
That's what they're saying.
Yes,
They've
my lord. Whenever they are giving, I am receiving. I am an applicant in the past year. Judgment is also passed on the Rule 18(1), and also consequential benefits are given. And they have given the effect on date as 13/4/2026. And my name is not included in the attendance register. It is they are writing in the separate sheet in the attendance register, and not in the sequence.
Only waiting for approval. They've asked for approval.
And they are filling all the other posts through transfer, my lord. So if they are
In any
filling
case, your promotion has been granted as far as 3 is concerned. We'll see the approval
It will be approved.
within period of 7. List on. Just put it after 10.
my lord, and they are also targeted me personally, and
No, we'll see. We'll give you a short date. We'll see
yes, my
for the
lord.
reporting compliance.
Yes, my lord.
10th of August, 11th of August.
Grateful.
So, Srimati 31.
Petitioner,
Yes.
there's a. There's nothing. So
Try to
far
take
as
instruction
Madam-
on the fee. How will you do it retrospectively?
Yes, Madam. There's nothing, Madam. We've asked them, as they said there's some government order. We've asked that document, Madam, but in our files, we don't have any such thing. Because, Madam, what has happened is the circular, Madam, on which we are relying upon, that is annexure E. The only explanation I was able to gather from the officials is that because it has been substituted, we are taking it retrospectively. The entire rule making methods in terms of the fee schedule, which was inserted, it was substituted.
Yes.
So because it was substituted prior to the first one, which is methods on 12/11/2020.
No, there's an express.
Methods, there are two
You're
things.
aware that the consent fees increased through government.
Let's make the
Notification.
submission. Under the water rules, methods, there was one amendment on 12/11/2020.
That's right.
Under which methods there was 26,000 which the petitioner is liable to pay, and they have paid.
Yes.
Now, methods, while the consent was being processed, methods, the new amendment came into picture. That is, methods, dated 26/10/2021.
Yes.
Now, methods, because it was substituted,
Where is this?
methods may see page 50. Yes, methods, page 50.
Page 50.
50 methods, amendment to Rule 32.
Yes.
Results found that results. The last line results in Rule 32 in Sub-Rule 2 for the table 1A, the entries thereto. The following shall be substituted, namely.
Yes.
This is the explanation which I was able to gather from the officials by the virtue of it being substituted. And it's substituted for the previous one.
What about
Which,
two? It shall come into force on the date they're published. The substitution also comes into force on the dates published.
sorry.
This can't, you can't apply the substitution rules in a.
The only logical bridge between the two, the date methods, that's 2020, November 2020 to October 2021 was that. That's then I was able to methods.
If you say that, we'll record your submission and deal with the matter.
That's if methods may allow me, I will. They've just told me there's some government order methods which has allowed them to take it retrospectively. I had to present it today, methods, but I was not able to get the
When do you want it? When do you want to present?
Methods may have it sometime next week.
All right, put it after
or
the week.
week after.
At the request of Learned Counsel for KSPCB list.
13th August. Yes.
Just call the passover and then we'll.
Passover matter. List 2, seal number 18.
Yes.
They have given a memo. Oh, not.
We try to reach consensus in terms of identifying the modalities. My learned friend had proposed that somebody from DLSA may be appointed. We have proposed 3 different modalities. We have suggested 3 experts. We have suggested 2 independent, competent, technically qualified organizations. And we have suggested not 3 modalities. Lordship has proposed modality 1, 2, and 3. Lord.
That's to begin with. That's all these are. It's an expensive affair.
We bear the cost to
Bear the cost.
We're not asking you.
We had asked you to come to a joint consensus.
That's we had proposed. In fact, I had proposed to my friend's colleague DLSA's methodology methods, where the DLSA member secretary of that particular district would be accompanied by their technical team and our technical team.
No, your technical team can assist any one of them that you think.
I'm sorry, minutes.
Your technical team can be present.
Yes.
At a part of the inspection team, and we'll appoint by joint consensus any one of them that you agree. At their cost.
They just gave it to me now.
But if your lordship were to see it,
They just gave it to me now.
Take your instruction.
I'll take my instructions, minutes.
Also on the how do you propose to go about the inspection?
Because methods, the violations which we have found out methods in their plan is something methods which we may not require so much of technical exercise, because methods have observed it's leaving of water, the wretched has not been cleaned. These are things which it's in their purview to come up with.
So they'll have to do it.
How action plan? They should be submitting an action plan. And based on that, in fact, the letter methods which they have given, the last annexure, which methods would find at page 185, they're saying we have given previously and action to be taken, but nothing on record for us. They've submitted methods.
we've given 3 options to them. We are okay with either of those 3 being picked.
There's another difficulty also. There's a violation. There's a proposed criminal action. That cannot through this.
We're not asking for.
Your unit is closed. We are not opening that unit.
Yes.
They are saying that let an inspection take place. It will highlight the compliances that needs to be done. That report will show it. If you accept that compliances by your team there, that it is sufficient that these things must be addressed, then they'll have some time to comply with those
that's my
observations.
Thursday. Then I will.
That's all. Once they comply with the observations, you lift your closure order. Whatever prosecution you want to take, you take.
Let's have it on Thursday.
Counsel appearing for the petitioner has handed over a memo setting out the proposing the names of experts and technical organizations. Learned counsel appearing for kspcb seeks time to take instructions in regard to the proposal. Please put it after 2-3 days. Monday, put it on Monday. Get it by Monday.
Yes, sir. Right. Third, Monday. 3rd August.
Great.
Yeah, 32.
So number 32, please do.
Beg my lordship's leave, before the matter starts, notes in this, I would be appearing for the intervener there. Notes there with respect to the guested probationers, notes in the grade of assistant commissioners, Tashildars, notes vis-a-vis that examination is concerned, notes, KPSC does not want to release the result notes of the successful candidates without the leave of the court. There is a memo also which we have filed. That is because of the fact that before your lordships passed an order in all other petitions. There was one order which was dated 31/7/2025 that the result shall not be released without the leave of the court. So in all other matters, your lordships have omnibus passed an order that the result shall be released and appointment shall be subject to the result of the petition. I think even this, my lords, would have to be just clarified to that effect. That is all. Because
we are hearing it finally now. We are in final hearing. You'll get the order.
Because in all other matters,
all other matters, those orders,
aspirants have already,
even those orders will dissolve and go by the normal case.
Quite right. But till whatever happens, then because it is not going to stall here or wherever, my lords. That is why if the results could be
a
announced.
separate issue. So let's finish this. Then we'll take up your interim applications after we finish this. Yes.
Lords, I was taking my lord to the requirement of consultation.
Yes.
And relied on Pattadi Makkal Kadichi. Then my lords were pleased to observe that it is also covered by discussed in Jayashree.
Because it was discussed in that.
Yes, and there, my lords, if my lords would kindly take volume 2 of the compilations at page the judgment in Jayashree Lakshanrao Patil commences at page 844. My lords may straight away come to page 1146, my lords. It was dealing with consultation with the backward class commission, National Backward Class Commission, under Article 338, capital B, which commences at page 628, page 1145. What is relevant for us would be, my lords, page 629 onwards, paragraph 629 onwards. The most important difference which is now is that which mandates that at page 1146.
Just give the compilations. Yes.
Well, page 628, that is the para 628 at page 1145. The Supreme Court extracts the requirements of Article 338B.
Yes.
And my lords, at page 1146, clause 9 thereof is extracted.
Yes.
The union and every state government shall consult the commission on all major policy matters affecting the socially and educationally backward classes. The most important difference now that is sought to is that every state to consult the commission on all major policy decisions affecting socially backward class. Class 9 is engrafted in mandatory form by using the expression shall. The states thus are now bound to consult the commission on all major policy matters affecting socially educationally backward class. For the purpose of this case, we need not elaborate on the expression policy matter occurring in clause 9 of Article 338B. However, in the facts of the present case, the decision of the Maharashtra government, which culminated in 2018 Act to exceeding for reservation as per existing law and to give separate reservation for employment under state and educational institutions for all policy decisions within the meaning of Article 338, Clause 9 of Article 338B. The word consultation occurring in Clause 9 is an expression which has been used in several articles. Then Black's Law Dictionary is referred at para 632 minutes. The consultation or deliberation is not complete or effective unless parties thereto make their respective points of view known to the others and examine the relative merit of their view. The consultation is a process which requires meeting of minds between the parties involved in the process of consultation on the material facts and points involved. The consultation has to be meaningful, effective, and conscious consultation. We may now notice few cases of this court where the word consultation as occurring in the Constitution has been dealt with. Then para 633 they refer to Chandramouleshwar Prasad, which concerned the promotion of district judges. Thereafter, at para 634, Sankal Chand is considered.
Case number ಬೇರೆ ಅದೇ case number.
Yes.
Para 637 is the conclusion, man.
Yes.
When the constitutional provision uses the expression consultation, which consultation is to be undertaken by a constitutional authority like National Commission for Backward Classes, in the present case, the consultation has to be meaningful, effective, with all the relevant materials and information placed before the Commission. As observed above, the National Commission for Backward Classes has been given constitutional status under Article 338B, has now been in numerous functions regarding backward classes. The Commission is now to advise not only the union government but the state government also, and various measures as enumerated in Clause 5. The objective of Clause 9 is to ensure that even the states did not take any major policy decision without consulting which is competent to provide necessary advice and solution, keeping in view the larger interest of backward class. We thus are of the considered opinion that the consultation by the state on all policy matters affecting social and economically which mandatory requirement cannot be bypassed by any state while the state takes any major policy decision. It is true that expression consultation in Clause 4 of Article 3 is not to be read as concurrence, but as held above, consultation has to be effective and meaningful. The object of consultation is that consultee shall place the relevant material before the person for whom consultation is asked for, and advice and opinion given by the consulting authority shall guide the authority who has to take for consideration. Now, what the state government is in its statement of objection telling is, yes, we did not consult. But after the act is challenged before this honorable court, we have written 2 letters, one to the National Scheduled Caste Commission, another to the National Scheduled Tribes Commission, and they have not objected to the decision of the state government. Therefore, it has to be taken as deemed compliance of the requirement of consultation.
Yes.
Therefore, my resolution submission is not a post-decisional communication. That too stating that now the act is challenged and it is pending before the High Court. Kindly advise that can never amount to a consultation, having regard to the content and meaning judicially assigned to the word consultation. 338(9), it has always been there that consultation has to take place.
Yes.
Then onwards, the earlier in volume 5, my lords, page 2362. A question arose, my lords, what is the effect of appointment of Upalokayukta without consulting the Chief Justice of this Honorable Court under the provisions of the Karnataka Lokayukta Act? My lords, at para 56, page 2399. Opinion of Lordship Justice Radhakrishnan starts from para 57 onwards. And after considering the earlier judgments on the word consultation, the fact situation there, my lords, commences at page 2404.
Yes.
Then, my lords, the para 77, the Chief Minister is legally obliged to consult the Chief Justice of the High Court and four consultees, which is a mandatory requirement. The consultation must be meaningful and effective, and mere eliciting the views or calling for recommendations would not suffice. This is exactly what the state has done in the present case. After the event, they say, please let us have your advice. The consultees can suggest various names from the source stipulated in the statute, and those names have to be discussed either in the meeting to be convened by the Chief Minister of the state for that purpose or by way of circulation. The Chief Minister, if proposes to suggest or advise any name from the source earmarked in the state, that must also be made available to the consultees so that they can also express their views on the name or names suggested by the Chief Minister. The consultees can express their honest and free opinion about the name suggested by the other consultees, including the Chief Justice or the Chief Minister. After due deliberations and making meaningful consultation, the Chief Minister of the state is free to advise a name which has come up for consideration among the consultees to the Governor of the state. The advice tendered by the Chief Minister will have primacy and not that of the consultees, including that of the Chief Justice of the High Court. I may point out that the source from which a candidate has to be advised consists of former judges of the Supreme Court or Chief Justice of the High Court. The persons who fall in that source have earlier held constitutional posts, etc. That may not be very relevant, the only from Placitum A at page 2405. That is not.
Yes.
Apart from the person's competence, integrity, and character as a judge, various other informations have also to be gathered since the persons who fall in that source subject. The government, as the Chief Minister, cannot advise a name from that source without making a meaningful and effective consultation after disclosing the relevant materials. This, in my view, is a sufficient safeguard against arbitrary selection and advice. Further, as already noted, the duties and functions of Lokayukta in such a situation, the legislature and their orders cannot be included. In such situation, legislature in its wisdom felt that no primary sin need be added. In my view, that this is the section, there is a language used in section by the Chief. I am therefore of the view that various directions given by the High Court, holding that the views of the have got primacy is beyond the constant. The Chief Minister, in my view, then, consultation has not been there. On that ground, the with no order as to cause. Then concurring, Madan local judgment, the views, my lords, is at para 127, page 2417. Or the Supreme Court held that the appointment is bad for non-consultation, but direction issued by the High Court to the extent that concurrence of the Chief Justice is required, that part was set aside. Here, my lords, at page 2417, the consultation, again, my lords, what is this true scope of consultation? What does consultation occurring in section 3(2)(b) of the Act postulate? The Learned Counsel for the State as well as Learned Counsel for Justice Chandrasekhar and the petitioner firstly refer to the above decisions to explain the meaning of consultation in the context of appointments, and secondly in the context of the issue whether view of the Chief Justice would have primacy over consultation. Then, my lords, what the High Court has held has been extracted. Then, my lords, at page 2419, para 132.
Yes. Yes.
Ashok Tanwar has extracted in Aranarai. The words and expressions used in the Constitution have no fixed meaning and must receive interpretation based on the experience. The same thing cannot be said in relation to interpreting the words and expressions in a statute. This court categorically rejected the view that consultation passed in Article 2 in relation to the appointment of High Court Chair to be read in the same way as that is to distinguish that it need not be concurrence. 133. In Kannadasan, it was noticed by that a collegium of judges had found Kannadasan unfit to continue as judge. In that context, it was where the expression retired judge would mean a person who was retired without blemish and not merely a person who has been a judge and therefore attention. It follows from the decisions placed before us that there is a clear distinction between consultation and the appointment of the Superior Court. For the former Chief Justice may consult the collegium. In both cases, consultation is mandatory. That is what I am emphasizing on. That here there has been no consultation is an admitted fact. Then, my lords, at page 2423, again, my lords, what is the essence of consultation is and in the case of reservation, my lords, there could be any counter proposal saying that either you reduce the reservation somewhere else or you refine it this manner, or no reservation is required at all because no enhancement is called for because it is they are already adequately represented. There are myriad alternatives. And page 2423, minutes. Good minutes. Yes. It is well settled, extracting M.M. Gupta edict notes. It is well settled that consultation or deliberation is not complete or effective before the parties thereto make their respective points of view known to the other sources, known to the other or others, and discuss and examine the relative merits of their views. If one party makes a proposal to the other, who has a counter proposal in his mind, which is not communicated to the proposer, the direction to give a counter proposal without anything more cannot be said to have been done after consultation. Full deliberation with identical material between the consultant and the consultee, it has to be there. Counter proposals or various alternatives have to be examined, and then the state is free to take its informed decision. Nothing of that sort has gone into. Then, Lords, I already submitted about the question of adequate representation. I took my Lords through the preamble to the Act and what according to them is the data that was placed, and I pointed out that there has been no comparison of population and representation of other segments of the society, except saying that when compared to the population of SC and ST, their representation is inadequate. Now, my lords, kindly take, again, my lords, going back to J.C. Lakshman Rao Patil, about the adequacy of representation, I just read out to my lords one paragraph from Pratar Makkala Kadichi. I don't want to repeat it. Now, my lords, in volume 2, J.C. Lakshman Rao Patil, which I read out to my lords in the context of what is consultation. Now, my lords, going back to the same judgment, my lords, the adequacy of representation is considered at my lords, the (462) onwards, my lords, there is pages. Which page? Paragraphs extract.
You want to refer to Jayashree's judgment?
Yes, my J.C. Lakshman Rao Patil.
That's at page 462, you want to say, paragraph.
Yes, my lords.
Yes.
Yes, my lords. Sorry, grateful, my lords. 1082. That's my lords. 1086. That is 50, about the 50% reservation, my lord, 50% cap. That is, my lords, it commences, my lords, at page 461. Sorry, but page 1085.
Yes.
Para 461.
Yes.
That is not the Indira Sani view, is a view of one of the Senate judges in Indira Sani is taken. Then, my lords, at page 1086, para 682 is extracted at the top of the page, my lords. That is from second line there. The Supreme Court considered this issue while answering questions 6A, 6B, 6C formulated by it in the judgment. The questions are produced here and above. Whether the 50% rule enunciated in Balaji is a binding rule, or any rule of caution, or only a rule of caution, or rule of prudence. Whether the 50% rule, if any, is confined to reservations made under clause 4 of Article 16, or whether it takes in all types of reservations that can be provided under Article 16. Further, while applying 50% rule, if any, whether a year should be taken as a unit, or whether real total strength of the cadre should be looked into. The Honorable Supreme Court at para 810 answered the questions in Indira Sani's case formulated by it, stating that the reservation contemplated in clause 4 of Article 16 of the Constitution shall not exceed 50%. In the same paragraph, Honorable Supreme Court has ruled that some relaxation in this strict rule may become imperative with a caution. In doing so, extreme caution is to be exercised and a special case is to be made out. The relevant passage from paragraph 810 of the judgment of the Honorable Supreme Court in Indira Sani's case, majority views reproduced that runs as under. While 50% shall be the rule, it is necessary not to put out of consideration certain extraordinary situations inherent in the great diversity of this country and the people. It might happen that in far-flung and remote areas, the population inhabiting those areas might, on account of their being out of the mainstream of national life and in view of the condition peculiar to and characteristical to them, need to be treated in a different way. Some relaxation in this strict rule may become imperative. In doing so, extreme caution is to be exercised and a special case made of. I may pause here and submit, my lords. In Cheprol, Leela Prasad Rao, what came up for consideration before the Supreme Court was full bench judgment of the Andhra Pradesh High Court, which held that insofar as the teachers in tribal areas are concerned, since people from non-tribal areas would not like to go on transfer to tribal areas, the state had granted them 100% reservations to tribals from that area in appointment of teachers. That was struck down by the Constitution Bench in Chebrol Leela Prasad Rao, and it said that even in such cases, 50% ceiling applies. I'll take my lords to Chebrol Leela Prasad after completing my reading of this judgment, my lords. Then, my lords, at para 462, after noticing the above proposition of the Commission proceeded to deal with this subject. In para 234, Commission has noted the Constitution judgment Nagraj observing that this court has again considered the aspect of ceiling of 50%. The Commission, however, proceeded with an assumption that Nagraj, this court has ruled that for relaxation, there should be quantifiable and contemporaneous data. Even that is not available in the present case. We may notice the exact words of the Commission in this, that is what the Commission had done there. They notice the Honorable Supreme Court has considered this aspect of the 50% of in its decision in Nagraj, wherein the Honorable Supreme Court considered the validity of clauses. However, Nagraj, the Honorable Supreme Court has ruled that the relaxation ceiling of 50% there should be quantifiable and contemporary data. The above has been again from the above, para 464. From the above, it is clear that the Commission read the Constitution Bench judgment of this court in Nagraj laying down ceiling of 50% may be exceeded by showing quantifiable data relating to backwardness. The above reading of the Constitution Bench judgment was wholly incorrect. This is exactly the reasoning given by the state also in its present. We may again notice that judgment of Nagraj in the above aspect. Nagraj is a case where the Constitution 85th Amendment Act is inserting Article 16 was challenged and articles in which was inserted above amendments, that is about the promotion matters. Then the Constitution Bench proceeded to consider submission raised by the petitioner challenging the constitutional validity of the provision. The Constitution Bench in Nagraj has noticed the maximum limit of reservation in para 55 to 59. The Constitution held that majority opinion Indira Sahni has held that rule for 50% was a binding rule and not a rule of prudence. Para 58 of the Constitution Bench judgment in Nagraj says, however, Indira Sahni, the majority held that rule of 50% laid down in Balaji was a binding rule and not a mere rule of prudence. In para 107, the Constitution Bench observed, if the state has quantifiable data to show backwardness and inequity, then the state can make reservation in promotions keeping in mind the maintenance of efficiency, which is held to be constitutional limitation on the discretion of the state in making reservation as indicated by Article 335. There is no whisper of requirement of efficiency in administration in the entire act or preamble. Constitution Bench noted in its conclusions 121, 122 and 123, para 123. However, in this case, extent of reservation is not the main issue concerns extent of reservation. In this regard, state concerned will have to show in each case the existence of compelling reasons, namely backwardness, inequity of overall administrative efficiency, before making provision for reservation. As stated of the impugned provision is enabling provision, state is not bound to make reservation. However, if they wish to exercise their discretion, make such provision, the state has to collect quantifiable data showing. It is made clear that even if the state has compelling reasons as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling limit of 50% or obliterate the creamy layer or extend the reservation. The Constitution Bench in 123 held that provisions of the enabling provision and the state is not moved to make it. If they wish to exercise, then the state has to collect, etc. Para 123, the above observation regarding quantifiable data, etc. Then the about whether a quantifiable data itself is a compelling circumstance that is considered at para 491 minutes. Yes. Para 490 at page 1096. The statement of objects of the bill. Could my lords get the page numbers?
Yes.
Page 1096.
Yes, sir.
The statement of objects of the bill clearly indicates that the state has formed the opinion on the basis of report of the commissions and has accepted the reasons given by the commissions, holding that extraordinary circumstance for exceeding the limit is made of. We have already in detail analyzed and noticed the report of the commission, and I have held that no extraordinary circumstances have been made out on the basis of reasoning given in the report. While the foundation itself is unsustainable, the formation of opinion of the state government to grant separate reservation to the Marathas exceeding 50% is unsustainable. It is well settled that all legislative acts and executive acts of the government have to comply with the fundamental rights. The state's legislative or any executive action passed in violation of fundamental rights is ultra vires the Constitution. The 50% ceiling limit for reservation laid down in Indira Sawhney's case on the basis principle of equality as enshrined in Article 16 of the Constitution. In para 808, the Indira Sawhney is laid down. It needs no emphasis to say that the principal aim of Articles 14 and 16 is equality and equality of opportunity, and that clause 4 of these is but a means of achieving the very same objective. Clause 4 is a special provision, though not an exception to clause 1. Both the provisions have to be harmonized, keeping in mind the fact that both are but the restatements of principle of equality enshrined in Article 14. The provision in Article 16(4), conceived in the interest of certain sections of society, should be balanced against the guarantee of equality enshrined in Clause 1 of Article 16, which is a guarantee held out to every citizen and to the entire society. It is relevant to point out that Dr. Ambedkar himself contemplated reservation being confined to minority of seats. See his speech in the Constitution set out in para 693. No other member of the Constitution suggested otherwise. It is that clear that reservation of a majority of seats was never envisaged by the founding fathers, nor are we satisfied that the present context requires us to depart from that concept. The Constitution bench of this court in M. Nagaraj has reiterated that ceiling limit on reservation fixed at 50% is to preserve equality. In paragraphs 111 and 114, the following was laid down. The petitioner submitted that equality has been recognized to be a basic feature of our Constitution. To preserve equality, a balance was struck in Indira Sawhney so as to ensure that the basic structure of Articles 14, 15, and 16 remains intact, and at the same time, social upliftment as envisaged by the Constitution stood achieved. In order to balance and structure the equality, a ceiling limit on reservation was fixed at 50% of the cadre strength. Reservation was confined to initial recruitment and was not extended to promotion. In Indira Sawhney, equality, which was protected by the rule of 50%, was by balancing the rights of general category vis-a-vis the rights of backward classes, N block consisting OBCs, SCs, and STs. Clear statement that any reservation, OBCs, SC, STs, shall not exceed 50%. We have found no extraordinary circumstance were made out in granting separate reservation to Maratha community by exceeding 50% limit of reservation. The 2018 Act violates the principle of equality as enshrined in Article 16. The exceeding limit without there being any exception clearly violates Article 14, which makes the enactment ultra vires. 494 is the conclusion. We thus conclude that 2019 Act as amended into granting separate reservation has not made out any exceptional circumstance. In the same judgment, my lords, what is meant by adequacy of representation is considered at paragraph 515 onwards at page 1104.
Yes.
There is no, sir. Whether the data of Marathas and that may not be relevant for, but then Marathas, how the adequacy has to be tested is what is laid down from para 515 onwards. The reservation under Article 16(4) of the Constitution is enabling power of the state to make any provision for reservation of appointment or post in favor of other backward class of citizens who, in the opinion of the state, is not adequately represented in services of the state. The conditions precedent for exercise of power are that the backward class is not adequately represented. Then, moreover, para 807 of Indira Sahni is extracted, which says, we must, however, point out that Clause 4 speaks of adequate representation and not proportionate representation. Adequate representation cannot be read as proportionate representation. Principle of proportionate representation is accepted only in Articles 320 and 332 of the Constitution, and that too for a limited period.
This you read. This you read last time.
This was read last time, Manoj. Then, Manoj, there is the next page, para 694. That also I have read to my lords. I will only point out para 520, Manoj, which I could not. The word adequate is a relative term used in relation to representation of different castes and communities in public employment. The objective of 16(4) is that backward class should also be put in the mainstream and they are to be enabled to share power of the state affirmative action. To be part of public service as accepted as is to attain social governance of the state is to play a key role in obligating the state for exercising the enabling power to grant. This has to identify inadequacy of representation. For finding out adequate representation, the representation of backward class has to be contrasted with representation of other classes, including forward classes. It is a relative term made in reference to representation of backward classes. My submission is that, my lords, no effort has been made to compare the representation of all the classes involved. Then, my lords, para 522. Then, para 521. The Maratha community is only one community among the numerous castes and communities in the state of Maharashtra. The principal castes in the state are scheduled castes, scheduled tribes, denotified tribes, nomadic tribes, special backward category, other backward general categories, and the minorities. A large number of castes and communities are included in the above class of castes. We may refer to the number of castes as SC 59, ST 47, OBC 348. The above details indicate that in a rough estimate in the state there are more than 500 castes and communities which include scheduled caste, scheduled tribes. The state cannot take any measure which violates the balance. The expression inadequacy has to be understood in the above manner. Along with my writ petition, Manoj, I have placed on record Annexure H, page 142, and English translation of it is at page 156. This is the report published by the Department of Economics and Statistics of the state government. This is published on 22nd January 2024. My lords would get the date at page 157. And that is in the amended writ petition I have filed. It is everything is handled. But don't start with the negative phrase that I have not given. Put together, you state there. He can collect it from here.
Yes.
You know how the government functions. Page 156 is the report, Manoj. As on 31st of March 2023.
Yes. Which is the judgment, economically weaker sections. ಹಿತ್ತು ಮತ್ತೆ ಇದು ಚೇಂಬ್ರೋಲ್ ತೋರಿಸ್ಬೇಕು. Yes.
Page 156 is the report, Manas. Report on the representation of scheduled caste and scheduled in the state civil services as on 31st March 2023. Date of publication, Manas, forward is at page 157. Bottom of the page, Manas, would get 22nd January 2024. Then, Manas, the Manas would kindly just turn to page 162. Para 4.1.
Yes.
As on 31/3/2023, total number of scheduled caste employees in the state government service is 18.65%, and the total number of scheduled tribe employees 5.05%. Next month, there is an error there. It should first start from the next line, para 4.2. In a group-wise classification, the percentage of scheduled caste in the total post in group A, B, C, and D is 18.55, 19.46, 17.99, and 25.58 respectively. Similarly, the percentages for scheduled tribes are 4.86, 4.98, 4.79, and 8.18. This is in a situation, my lords, where this is at a time when the reservation prescribed was 15% for scheduled castes and 3% for scheduled tribes. The increased percentage has occurred because of the two reasons. One is about the vacancy-based roster, which they were required to abandon on 10th February 1995, on the day when the Supreme Court rendered its judgment in R.K. Sabharwal. Even after 31 years, it is continued. Second is, my lords, number of candidates belonging to scheduled caste would have been selected on their own merit. And to borrow from the judgment of the Supreme Court in R.K. Sabharwal, when such a situation occurs, it is a case for review of reservation because they have made sufficient strides of progress. That was the phraseology used by R.K. Sabharwal. Then next parameters. Trends from 2019 to 2023. An analysis of the group-wise data for scheduled caste over 5-year period from 2019 to 2023 shows their representation to be 16.67%, 16.57%, 16.84%, 17.34%, 18.65% respectively. An analysis of the group-wise data for scheduled tribes over the 5-year period from 2019 to 2023 shows their representation to be 4.61%, 4.68%, 4.72%, 4.9%, and 5.5%. All in excess of the quota of 15% and 3% respectively. Then, my lords, if my lords would come to the bottom of that page, my lords, number of departments with representation as prescribed by the government. That is, my lords, less than 15%, there are only 2 departments. And 15 to 17%, 2 departments. It is more than 19% in 29 departments. Out of the total 33 departments. Analyzing the above, that is at page 163, my lords. Yes. Analyzing the table above, out of the 33 departments for which data has been collected, 2 departments have a scheduled caste proportion of less than 15%, and 2 departments have representation in the 15% to 17% range. The remaining 29% have representation of more than 19%. This means that in 89% of the departments, the representation filled post is higher than 17%. The next para about the scheduled tribes. The number and percentage of scheduled tribe employees in the education department, home department, and health department, and family welfare department or 3.66%, 5.56%, 7.40% respectively, showing a higher representation of scheduled tribe in field posts. Details are provided in para 3. Examining the percentage of revenue for Department of Information Technology, Biotechnology, Science and Technology, the Tourism Department 17.9%, 19%, and Department of Kannada Culture 12.7% have the highest representation of scheduled tribes occupying the top 3 positions. Their own report. And next tabular column, in none of the departments, 3% was the stipulated reservation for scheduled tribes. As against in 25 departments, it is between 3 to 7, more than 7% in 8. In no department, it is less than what is prescribed. Then, my lords, the state's case is that they have based the enhancement in the reservation pursuant to Namma KAS committee report. Namma KAS committee, after the report on which they enhanced reservation, Namma KAS was again called upon to submit a report regarding providing of internal reservation. That report is submitted on 1/8/2025, which is Annexure J at page 168. Kindly see, my lords, the English
Continue tomorrow.
Great.